Good morning readers. I, Harish Budhu, warmly welcome you to my channel. Learn as much as possible from my handwritten articles. Open letter to His Lordship, Chief Justice, Ashraf Khan High, Supreme Court. Part 4. This 18th of May 2020. The government and the parliament cannot afford to remain oblivious to the needs and aspirations of the people to have an economical, efficient and expeditious system of justice. Your Lordship. 1. This fourth part, of the series of letters addressed to Your Lordship, welcomes you. They could well summarize the feelings of the vast majority of thinking Mauritians. Before writing, we consult our think tank. It comprises of people from every walk of life, and from all across the country. So, in a sense, we can say that they reflect the views of many citizens. All said, in truth and in effect, we are but doing the work of a free press, and of course, no patting on the back. No self-congratulation. As usual. 2. Unfortunately, some of the photocopies reproduced yesterday were of poor quality. We had apologized. However, we deem it very appropriate to highlight some of the eye-catching or eye-opening important points of yesterday's pages 7 and 8, and that, for our readers of Facebook and listeners of YouTube. A public interest litigation bill has been one of the most important innovations in the Indian judicial process of the last 2 decades. It emerged in response to a need to make judicial process more accessible to the disadvantaged sections of society and to ensure adequate judicial protection of their human rights. B. In respect of the other fundamental rights, the Supreme Court of India has been flexible as far as the locus standi of the petitioners are concerned. In a recent case, the Supreme Court held that it would be most reluctant to uphold the plea of delay where usurpation of a public office was alleged. C. The courts are not mere dispute-settling institutions but have to play a political role in securing human rights entitlements guaranteed by the Constitution. D. Public interest litigation is essentially inquisitorial and has various elements of an ombudsman. The appointment of commissioners by the court to collect data in support of a petition, where the petitioners lacks the professional expertise to collect such information, is the most valid example of the unorthodox processual character of public interest litigation. E. The growth of epistolary jurisdiction under which a letter written to a judge or even a newspaper report could trigger the judicial process is another example. F. In public interest litigation, the courts combine the function of an ombudsman and a human rights court. G. The evils are so deep-rooted that their eradication would take decades, if not centuries. H. It must be seen as one of the strategies of making justice available to common people. 3. The concluding remarks of S.P. South in the preface of Sankita Ahuja's book on People, Law and Justice are equally as important as those quoted above. 4. Against that Indian Public Interest Litigation Act backdrop, the following cases on police speak volumes. A. W.P. Cree No. 539 of year 1986, West Bengal. A letter dated 26 August 1986 was sent by D.K. Basu to the Chief Justice P.N. Bhagwati regarding newspaper reports published in the Telegraph entitled Death in Police Custody and in the Indian Express entitled Man Dies in Lockup. The letter was registered as a writ petition. The Commission pointed out that the duty lay on the law enforcement agency to ensure that a detainee does not suffer violence and therefore stressed the importance of the procedure for arrest and inquiry. B. W.P. Cree No. 592 of year 1987, up. A letter was sent to the Chief Justice of India by Dr. Johri regarding the death of a man in police custody. The letter was registered as a petition under Article 32 of the Constitution. C. CWP No. 123 of year 1987, Rajasthan. A letter was sent to the Chief Justice complained of the terror created by the police against the Adivasi. The letter was registered as a petition under the Article 226 of the Constitution. D. Cree Origin Jurisdiction, Delhi. The SC took suo moto notice of an article in the Hindustan Times about the death of a South Delhi businessman in custody. He had apparently been tortured and had died under suspicious circumstances while being questioned by the Enforcement Directorate. CW number 3393 of year 1990, Delhi. A petition was filed under Article 226 of the Constitution after the Mantle riots based on the October 1990 issue of the video magazine News Track. 5. We will provide some more examples from Sankita Ahuja's book about the wonders of Public Interest Litigation Act tomorrow. Just think of the chaotic situation in our own police force. To be continued. Keep reading, keep learning. Like and subscribe for more thrilling articles. Thank you for watching.